Ready? Legal matter, exercise number 76. Start. The alleged motive for attacking Professor Jacob was that he was incorporated a question for the internal examination of BCom, paper criticizing Prophet Muhammad and Islam. The prosecution case is that the respondent gave medical aid to one of the wounded accused in pursuance of a previous plan that if and when any of the assailants got injured in the attack on Professor Jacob, then immediate medical treatment would be given by the respondent to the injured. The respondent stitched the back of an assailant, which is not the job of a dentist. The respondent, along with the other accused, is a member of the Popular Front of India, a Muslim organization, and was head of its medical committee. Certain documents, CDs, mobile phone, books, etc., including a book called Jihad, were allegedly seized from his house and car. Stop, next para. The prosecution has placed reliance on the proviso to section 43D under bracket 5 bracket out of the Unlawful Activities under bracket Prevention bracket out Act 1967, which states that the accused shall not be released on bail if the court, on perusal of the case diary or the report under section 173 CRPC, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Stop, next para. On the other hand, the case of the respondent, as disclosed in the counter affidavit filed before us, is that even according to the prosecution case, the respondent was not one of the assailants, and he is not named in the FIR in para 13 of the counter affidavit. The respondent has stated that the attack on Professor Jacob is a crime which is to be condemned. However, as a pretext to the investigation, the police had lashed out on a reign of terror on innocent people of the minority community. People who are totally innocent or even had no knowledge of the crime have been falsely implicated. 54 persons have been made accused in the crime. Many residential houses, mosques, and offices were raided and searched, and even minor children and women were cruelly tortured, both physically and mentally. Holy books and other religious books were thrown out, seized, and taken away and bundled in police stations. Warlike atmosphere was created in mosques. Daily prayers were disrupted, and men illegally detained and physically tortured in custody, and false cases booked against innocents. Stop, next para. It is further alleged in the counter affidavit that the Popular Front of India, which is PFI, or the Social Democratic Party of India, which is SDPI, are not militant or terrorist organizations. There is no history of crimes against the party or its workers. They are not banned organizations. The SDPI is a political party recognized by the Election Commission, and the PFJ is registered under the Societies Registration Act. Stop, next para. The respondent has alleged that he is a dental surgeon hailing from a respectable family. In Aluva, his father, late Dr. Abdul Karim, was a doctor loved and respected by all, who died as a civil surgeon while working in the government hospital Perumbavoor. In 2001, the respondent started AI Amin multi-speciality dental hospital in Aluva. Five other doctors, including the respondent's wife, who is also a dental surgeon, are working in the said hospital. The respondent has a son aged 9 years and daughter aged 5 years. He claims that he has a very good reputation and is loved by all due to the services rendered by him to the poor and needy. The respondent's elder sister is a postgraduate in zoology and his younger sister is a law graduate. The book entitled Jihad, said to have been found in his house, was a Malayalam translation of a book written in Urdu in 1927 by a well-known and respected religious scholar, Maulana Sayyid Abdul Allah Mandud, and has been in circulation for 83 years and is available in many book shops. The respondent has alleged that he has been falsely implicated only because he medically treated one of the alleged assailants. Stop next para. At this stage, we are not expressing any opinion as to whether the allegations in the versions of the prosecution or defense are correct or not, as evidence has yet to be led. However, we would like to make certain observations. Stop next para. We are present only considering the bail matter and are not deciding whether the respondent is guilty or not. Evidence has yet to be led and the trial yet to commence. Hence, the prosecution is yet to establish by Professor beyond reasonable doubt that the respondent was part of a conspiracy which led to the attack on Professor Jacob. The case against the respondent is very different from that against the alleged assailants as he was not there. Stop. Thank you very much. Guys, I'm requesting please always try to repeat the matter so that your fluency and accuracy will improve. And also there is one more request, please subscribe my channel so that you can get the first notification on legal and general matter. Thank you very much.